chat.
Welcome everyone to our webinar on understanding term sheets. My name is David and I'm a senior lawyer in LegalVision's capital raising team. I'm joined today with my colleague Zoe, who's also a lawyer in our capital raising team. We'd like to start with an acknowledgement of country. LegalVision acknowledges and pays respect to past, present and emerging traditional custodians and elders of this nation. In particular, the Gadigal people of the Eora Nation, whose land LegalVision's headquarters is situated on, and the various lands on which those of you are joining us today. Before we begin, just have a couple of quick housekeeping tips. Everybody will be emailed a copy of this webinar recording. You'll have an opportunity to submit your questions, which we'll answer at the end, so please use the chat box. And there'll also be a survey at the end of the webinar. All of the participants today are eligible to receive a free complimentary legal consultation. In order to register for that consultation, you'll need to fill out the survey at the end and leave your details. So let's get started with the main purpose of today's webinar. The topics we're going to cover are: when do I need a term sheet? What are the standard terms? Some term sheet tips, and then we'll deal with any questions you might have. So, when do you need a term sheet? The overall purpose of a term sheet is to ensure that the investor and the companies, or sometimes the founder, are aligned on the material terms prior to getting involved in negotiating the long form documents. Term sheets usually aren't binding. They're usually for VC submitted term sheets, confidentiality clauses and exclusivity clauses that are binding. And the reason that is because VCs will often want to do some level of due diligence into the company. And whilst they're incurring time and expense running that due diligence, they don't want the company to be out talking to other investors. The key benefits of running a term sheet before getting stuck into the long form documents is it reduces any misunderstandings, because when you're drafting the long form documents, you can refer back to the term sheet. And sometimes it shortens the negotiations because you refer back to the term sheet and say this was already agreed. So it saves you time and it can save you costs. It can also be in a situation where you're using the term sheet as a way to reach out to investors, a good starting point. It's important to remember, though, that VCs often will have their own term sheet, and they will usually want to put that one forward. If we head over to the next slide, we'll have a look at some of the key terms that you need to understand to be ready to either negotiate or prepare a term sheet. The $1 million question, or sometimes the $1 billion question, is: what is my company's valuation? There's two types of valuations you'll see recorded in term sheets. The pre-money valuation, which is what your company is worth before the investments in this round of financing, or the post-money valuation, which is how much your company will be worth after this round. How this affects you is in relation to the share price. So if you're valuing the company now at $10 million and raising $1 million, after the round, the company will be worth $11 million. So the investor's investment is taken on the pre-money basis and they get a share of the overall company. If we look at the post-money valuation, if we're taking a $1 million investment and post-money we're only worth $10 million, then the company's only worth $9 million before the investment, and therefore the investor would get a bigger share of the company for the same dollars invested. One of the things that also affects the share price is whether the round is calculated on a fully diluted or undiluted basis. It's important to understand that dilution is really a reflection of everyone's overall ownership. Founders start off owning 100% of the company. As you issue more shares to investors, your overall ownership of that company decreases. That decrease is the dilution effect. So the things that can sometimes affect dilution or an investor's investment on a fully diluted basis is any securities you have, which are things like convertible notes, safes, or options under an option plan. because they haven't been converted into shares yet, but they're a right to acquire shares at a later point in time. If an investor is investing on a fully diluted basis, they want to assume that all of those shares have converted. So they will take into account the number of shares on issue, assuming that they've converted. Now, fully diluted isn't a fixed term. Sometimes investors will want it to be defined. The negotiation point, and sometimes the wiggle room to get a better deal for founders, is how you define fully diluted. Does it include, for example, all of the ESOP that's been set aside, or does it only include the portion of the ESOP that you've already issued to your employees? The overall impact of the dilution, the investment on a fully diluted or an undiluted basis, is really who gets to bear that dilution effect. If an investor comes in on a fully diluted basis, then the shareholders are the ones who are diluted by all of those options and safes. And if it's on an undiluted basis, then everybody shares the dilutionary impact. If we head over to the next slide, another key term that usually sits in term sheets, or you might see in a term sheet if you receive one from an investor, is restrictions. Restrictions on what the founder can and can't do with their shares. They're usually put in place by sophisticated investors to protect their investment. They're usually investing in a founder's long-term relationship with the company. The most common type of vesting that we see is a 4-year vesting with a 1-year cliff. What that means is if you don't remain with the company for at least 12 months, then you don't get to keep any of the shares that you've been issued. So you're not really legally entitled to them. If you serve the initial 12-month cliff period, then the remaining 75% of your shares will vest, usually over an equal monthly basis for the next 3 years. The consequences of a founder leaving during the vesting period is usually that they lose all of their unvested shares, and the company has sometimes a right to buy back the vested shares. The way that you can protect yourself from founder vesting or more unfair founder vesting is set out certain situations where shares should automatically vest. For example, if a founder was to suffer a total or permanent disability, or if they were to suffer death, then it wouldn't be considered fair that their estate or themselves miss out on the benefits of their shares. So in that situation, the shares should automatically come vested and the founders get to have the benefit of them. Now, another way you can protect yourself is for your work to date. So rather than vesting applying to all of your shares, if you have worked for a significant period of time in your company, and usually a lot of founders are taking below market salaries, then it wouldn't be fair for you to be subject to a position of when you raise capital that you could end up walking away with nothing. So often you try to carve out a percentage of the shares from vesting so that you get to keep them even if you leave. For example, you might say 25% of the shares are mine and 75% of my shares are subject to vesting. The other thing that you need to consider is if you've actually put money into the company and you have therefore paid for a portion of your shares up front, those shares shouldn't be treated as if you are getting them for sweat equity. They should be treated for as if you paid for them, and therefore you shouldn't run any risk that you walk away without any compensation. One next concepts that we need to consider when we think about vesting is bad leaver provisions. So if we head over to the next slide, what you'll hear often with vesting that goes hand in hand is the term sheet will often refer to what's called customary good and bad leaver terms. It might not set out what those terms are, but if you're putting forward a term sheet and you're willing to offer good or bad leaver clauses, then you usually want to set out what they are. The way that bad leaver terms work is if you're a defined bad leaver event, which you can be controlled to, and they're usually serious offences, then a portion on exiting the company, and it doesn't necessarily have to be during the vesting period, your shares are usually treated differently. And the way that they're treated differently is bad leavers shares are usually, even the vested ones, are acquired at either nominal consideration, like $1, or they're at a discount to the fair market value. And that's usually to be reflective of the wrongdoing that they caused the company. As I said, with the good and bad leaver terms, they don't always apply for the vesting period. You can be into a situation where you've served your 4 years, all of your shares are vested. However, if you leave on bad terms, then the company gets to buy back all of your shares. So it's important to understand what's being agreed in terms of good and bad leaver, how long they apply for, and what the consequence is in terms of exiting the company. Another founder restriction that we often see are restrictions on founders selling their shares. The most common type of founder restriction is to say that the founder can't sell its shares for at least the next X number of years. That could be 2, 5, or sometimes longer, depending on what the overall growth of the company is going to be. What founders usually want to negotiate is that they agree to be locked up into the company, but there is an agreed percentage which they can sell down. And the reason why you want to negotiate this is in future capital raises, that's about when the valuation is high and there's more appetite for purchasing shares, the founders can often benefit by selling down a small proportion of their equity and cash in on that amount. Another term that you'll often see in term sheets, which doesn't necessarily just impact founders, but also protects founders, is the non-compete and non-solicitation clauses. It's standard for these clauses to apply for the period of which somebody holds shares and at least 2 years afterwards. They prevent shareholders and founders from taking away current staff and contractors and clients of the company, and they also prevent the founder from going out and starting a competing business or other shareholders from competing businesses. So what I'll do now is I'll hand over to Zoe to talk through some of the other key terms that you'll find in your term sheet.
Thanks, David. So the next category of terms often contained in a term sheet will relate to how decisions about the company are going to be made going forward. Company decisions are usually made by the board of directors or the shareholders, or sometimes both of them. And who decides what is usually set out in the shareholders agreement, which is often negotiated as part of the transaction documents when your company is raising money. Making sure that you understand the terms that relate to the decision-making of the company in the term sheet is an important way to ensure that investors and the founders are on the same page about how decisions of the company will be made going forward and the operation of the company as well. The amount of decision-making power that you grant to your investors through the term sheet and the transaction documents themselves will ultimately depend on how much you want the investor to be involved in your business, whether they have expertise that you want them to offer up as a board member, and those kinds of considerations. So the first term that you'll often see relates to the composition of the board or the board control. An early stage company will often only have 1 or 2 directors on the board and maybe a couple of advisors or what are called observers. And as I mentioned before, the board of directors plays a really important role in the decision making of the company because they have votes and they can vote on certain matters. And for that reason, investors will often request the right to appoint a member to the board, and this is essentially their way of having a say in the future direction of the company. Usually each director will have 1 vote. So if there are, say, 4 directors on the board and the investor has one of those board appointments, then they'll essentially have 1/4 of the influence on the board of directors. So that's why you need to carefully consider whether or not you allow an investor appointment and the impact that this will have on the ability for your company to make the decisions that it needs to make. If you do decide that you would like an investor director, there are certain ways that you could consider counteracting the influence that they would have. One example of that is updating the term sheet so that as a founder, you have the ability to appoint 3 board members, for example, and the investor only appoints 1. So that way the founder still retains control of the board and the decision making. And then another option that you could consider is offering up the investor, instead of a board seat that gives them the right to vote, you give them the right to appoint an observer. An observer doesn't have the right to vote on those board decisions, but they have the right to attend the board meetings, and that can give the investor the opportunity to have oversight on the company and have their say without actually having that voting right itself. And then, so as I mentioned before, there are decisions that can be made by the board, there are decisions that can be made by shareholders, and as a general proposition, it's common for decisions relating to the future of the company to sit with shareholders, and then decisions relating to the day-to-day operation of the company to sit with the board. So as well as having a seat on the board, investors may set out in the term sheet the certain decisions that they will require be made by shareholders rather than the board. But it's often beneficial for early stage companies to limit the decisions that can be made by shareholders, because getting shareholder sign off on things can be a bit of a nightmare sometimes. It can take time. So if the term sheet sets out specific matters that you will need shareholder sign off on, you should consider the impact that those matters will have on the ability for the company to make the decisions that it needs to make. And you should also consider the specified level of approval that's required for those decisions. So what are called ordinary approval, that usually will require 50% of shareholder or board sign off, and then special approval will usually require 75%, unanimous requires 100%. So just consider the level of consent that's required, the decisions that they relate to, and whether that makes sense in the context of your business. And then next is what are called veto rights. The term sheet could set out that the investor will have certain veto rights, although it may not use that terminology specifically. And what a veto right is it means that the company won't be able to make a decision without the consent of the investor. So usually those veto right matters are reserved for items that have a significant effect on the value of the business. For example, the investor might need to specifically consent to an exit event if that were to occur. And it is common for the veto rights to only apply to a specific investor, usually a lead investor in a round. But sometimes it may apply to a class of investors. For example, you require the consent of 50% of the Series A shareholders. We've seen that sometimes as well. So just again, consider what impact that would have on your business, whether getting the consent to those decisions will be particularly onerous in the context. So something that we haven't touched on yet is the class of shares that are going to be issued to the investor as part of your raise. Usually companies will be incorporated with what are called ordinary shares, and therefore the shares that the founders themselves hold will usually be ordinary shares as well. But investors may request what are called preference shares, and it's common practice for the class of the shares to be named after the specific round. For example, at the seed round, investors may request what are called seed preference shares, and so on and so forth. The rights associated with those preference shares will usually be documented in the company's constitution. So that is why you'll often see the constitution being another transaction document that's negotiated as part of your capital raise. And the key differences between the ordinary shares and preference shares are that preference shares will usually have a liquidation preference and anti-dilution rights. So I will discuss what those mean now. Liquidation preference essentially helps a VC to protect their investment, but it will also directly impact the amount of money that's paid out to founders and other shareholders on what is called a liquidation event. So it's really important for you to understand exactly what the liquidation preference terms are. A liquidation event will usually be something like a liquidation, a winding up, a sale of the shares or the assets of the company, or some other exit event. And the liquidation preference essentially determines the amount of money that the investor is entitled to receive out of the money that's received from that liquidation event. So the liquidation preference in relation to the class of shares will be described as a number. So for example, a common liquidation preference is 1 times, and this means that the investor will be entitled to receive money out of the liquidation event equal to at least 100% of the investment that they made. And that money comes to them in preference to other shareholders, ordinary shareholders usually. But in the current climate, we're seeing liquidation preferences of more than 1 times as VCs try to compensate for the increased risk. We've seen liquidation preferences of up to 1.3 times. So in the case of a 1.3 times liquidation preference, if the investor invested $100,000, say, they would be entitled to $130,000 of the money from a liquidation event before any of the ordinary shareholders are entitled to anything out of those proceeds. So that essentially means that the ordinary shareholders will receive $30,000 less than if the investor had a 1 times liquidation preference. So when you're looking at the liquidation terms in the term sheet, you need to take note of the number that is the liquidation preference. And then another thing that you need to take note of is whether the shares themselves are participating or non-participating shares. Participating shares essentially allow the investor to double dip from the money received from the exit event. So that will reduce the money paid to ordinary investors even more. And so you should be wary of that. And non-participating shares are what are standard in the Australian market. So that's what you should hopefully be seeing on the term sheet. And then the other term in relation to preference shares that is relevant is what is called anti-dilution rights, which is what I'll discuss next. David mentioned the impacts of dilution on the shareholding earlier in the presentation. And anti-dilution rights are included in the terms to essentially protect the investor from dilution in their shareholding if the company issues shares at a lower price, a lower share price than what the investor had paid. That's what's often referred to as a down round. And the most common type of anti-dilution mechanism is what's called the broad-based weighted average clauses. That's the thing that you'll often see in term sheets. And under those anti-dilution clauses, some of the dilution will be borne by the investor, but not all of it, and they don't get out of it altogether. But what you should be wary of accepting is what's called the full ratchet anti-dilution clause, as this is super investor friendly and puts the investor in the same position as they would have been if there was no down round and was no dilution to their shares. So they don't bear any of the dilution at all under a full ratchet. Those aren't that common in the Australian market, so you should be wary of those. Next, I will discuss what are called drag and tag rights, which you'll see in the term sheet quite frequently. It's hard to know what they are until you understand, but what they are is essentially a way for investors to have control over a potential liquidation event, but they can also provide protection for minority shareholders and the founder themselves as well. So beneficial for essentially all parties, but you need to understand what exactly they do. And as I mentioned earlier, the shareholders agreement is commonly negotiated as part of the transaction documents, and the drag and tag rights, they'll usually be contained within the shareholders agreement, so will form part of the negotiation of that. What tag rights are is they essentially protect the rights of minority shareholders if a majority shareholder wants to sell or proposes to sell a certain threshold number of their shares. The tag right allows minority shareholders to participate in the sale on the same terms as the terms that that majority shareholder has. So it essentially allows minority shareholders to exit the business if there is going to be a change of control or a significant change in the shareholding of the company. And then drag rights are a way for the majority to force an exit event. For example, if there was a buyer that wanted to buy 100% of the shares, but 5% of the shareholders weren't willing to sell, the drag rights will essentially force those 5% of the shareholders to sell their shares under the proposed transaction. So yeah, like I said, just understanding what those mean and looking at the thresholds in relation to the shareholding in your company, and particularly the founder's shareholding, is a really important consideration when agreeing to the terms of the term sheet. And then finally for me, you will see terms relating to information rights of the investors in the term sheet. Those will outline the information that the company must deliver to the investors beyond that's required by the law, and common documents will include budgets, management accounts, financial statements, those types of things. And then certain funds and certain investors have additional reporting requirements that may mean that you need to provide them with even more information. And those requests are pretty standard, but you should still get comfortable that you'll be able to provide those documents to the investors as required. And just look out for things that you might not be able to provide. For example, if the investor was requesting audited financial statements, that would obviously be really onerous and costly to prepare. So we would want to push back on that requirement for sure. And now I'll hand back to David to discuss some tips from us in relation to term sheets.
Thanks so much, Zoe. You did a fantastic job there. I think the most important thing really to take away from everything we've discussed so far in this webinar is everything is negotiable, and your specific circumstances will put you in a different negotiating position to anyone else, and that not every investor will always ask for the same things. Though if you're putting forward the term sheet, then you have some control over the terms you want to offer to investors. And if you're taking investment from VCs and they're putting forward the term sheet, there will be some things in there that they're not willing to budge on. Now, one of the most common questions we get is, can we deal with multiple term sheets? Can we shop around? I briefly touched on this earlier. What's important to remember is when you're putting forward a term sheet, you can send it out to any of the investors that you wish to send it out to, and those investors may negotiate the term sheet. However, you wouldn't send out multiple term sheets with different terms to different investors, because usually everyone will be closing on the same terms. So what you would do is you'd send out the same term sheet, and to the extent that they come back negotiated by an investor, you try to find a position that you land on with in terms of what is the agreed terms for that round. On the other side, where you're receiving a term sheet from a VC usually, in those circumstances, it's okay to receive multiple term sheets from VCs. However, you wouldn't want to sign the term sheet and commit to it. And even though it's not binding, do that with multiple VCs trying to get multiple deals on multiple terms. It's important to remember that you wouldn't want a VC to pull out of a deal, and you wouldn't really want to pull out of a deal on a term sheet either. So before you sign a term sheet, it's really important that you understand the terms, you're happy with them, and you've taken some advice into what they really mean. One of the terms that really is negotiable and sometimes has a heavy impact on early stage companies is legal costs. If you're putting forward the term sheet and you're dealing with more of a friends and family round or an early stage seed round, there's no significant lead investor. The ordinary position is really each party bears their own costs throughout the transaction. The exception is where an investor is coming in and they're the lead investor, and this usually happens in a situation of a VC. There's an expectation that the company covers part of that cost. Now, the reason why that sometimes happens is lead investors usually doing all the negotiations on behalf of everyone in the round, so they're incurring costs that they wouldn't ordinarily incur, and otherwise they're sometimes doing complex due diligence on the company. Now, because not everyone is bearing those costs equally, the lead investor says the company should pay some of those costs to compensate them for the work they're doing for everyone else. The benefit to the founders is not having to negotiate a term sheet or a deal with multiple investors will end up saving you money. But it's important that you do a couple of things. One is cap those legal costs to a reasonable amount. And what that reasonable amount will really be will depend on how late in the stage your company is and how complex the due diligence is. If you're operating in a fairly unregulated market, early stage due diligence is usually quite light touch. If you're in a highly regulated market and you're a late stage company, due diligence is going to be quite extensive, and there will be some significant time spent on both sides. So you'll expect the legal fee contribution to be a bit higher. That concludes the main content of our presentation. So I'll hand over to Zoe now, who can talk through what are our next steps and how we can get onto those questions.
Perfect. Thank you, David. So you might find just before we get to that, you might find our Startup Equity Toolkit helpful. It contains an equity term sheet template and a fully functional cap table, which is an absolute lifesaver, I must say. And you can download it via the handout section in your webinar panel, I understand. And we also have an upcoming event that could be of interest to you, franchising your business, what to include in your franchise agreements, which is on the 26th of October. And you can register using the little link in the slide there. We'll be answering your questions shortly, but while you submit them via the live chat box, we'll take a minute to tell you about how we can help you get ready for your capital raise and about our membership options. So our team, the team that David and I are in, provides end-to-end guidance with capital raises, from term sheet reviews and assistance with transaction documents through to completion, signing, the ASIC updates afterwards. We can help with all of it. To prepare for your capital raise and to get your startup ready to grow with the money. We find our clients often need to do a lot of activities that require legal assistance or oversight, such as bringing on new employees, creating business contracts, those types of things. And our LegalVision membership can help you prepare for that next stage in your business. For a fixed monthly fee, you not only receive cost certainty, but all-inclusive benefits like unlimited document review, unlimited consultations, so you can book in as many meetings with us as you need to discuss your legal needs. And your membership also offers unlimited trademark registration and so much more. To learn about how membership can help your business, you can request a free consultation by leaving your contact details in the survey that will be at the end of this webinar. And now I think we're going to take some time to answer some of the questions you've sent through. David, have you seen any of the questions?
Yeah, so there's some really good questions coming through. Hopefully we can get through all of them, though to the extent that we can't, then I apologise in advance. I think one of the first questions that somebody has put through, which is a really good one, is this presentation was really presented in a way talking about equity capital raising, but there is other ways of raising capital through safes and convertible notes. And in those circumstances, the term sheet might look a little bit different. And the reason being is safes and convertible notes don't bring on an investor who has instant rights as a shareholder. So a lot of the rights that attach to shares are often not negotiated in a safe or convertible note round. So a safe or convertible note term sheet will usually be quite a lot simpler, and it will deal with more things around the commercial terms of what sort of discount you want to offer in that round, and if there's going to be a valuation cap, or if there's any special needs like what's called a most favourable nations clause, where effectively you promise not to give somebody else a better deal after somebody comes on to a safe. Another really good point somebody brought up was, is it possible, sorry, just reading through that one. Oh, sorry, they're coming through fast. Whether we should, from our experience and observation, what's the typical distribution of effort in negotiating economic versus governance terms? Is it 50-50, or does it change as the company raising in later stage? I think and I apologise, I don't get the question completely right. So negotiating the economic terms will usually be separate to negotiating governance terms. Negotiating the deal in how much your company is worth and the valuation measure is usually done in tandem with what the company believes they're worth using their own valuation methodology, and what an investor believes the company is worth using their valuation methodology. Now, that's going to be important in the governance because that will set out how much shares and what percentage overall equity the investor gets. And the general rule of thumb is the bigger the percentage of equity, the bigger the control that investor might have and the more negotiating power they have. In terms of governance rights, the points that founders should really be trying to focus on is founders know what's best for the growth of the business and know what's best to run the business and build the business. Sometimes strategic board players, and investors could be those strategic board players, have great industry connections and have great advice. However, they aren't usually the sole decision makers, so you don't want to give them extra rights like veto rights over key business decisions. So it's really important that you separate business rights out of the governance as far as possible so that investor directors don't block them. In terms of the shareholder rights and even getting a board seat, and I think there was a question about board seats, usually want to take by rule of thumb is you don't want to end up with a large board. It's very difficult to make decisions. Meetings go on for longer and you end up in a situation where you're spending more time talking about decisions than actually going out and taking action. So we often see that Early stage startups usually have a board of no more than 3. Sometimes they extend that to 5 in certain situations if you want to bring on a few strategic directors. But you want to make sure you have 3 of 5 or 2 of 3 of those board seats. So you usually don't ever want to allow somebody to have a board seat, or at least not a right to appoint a board seat. You might choose to appoint them, but not a right to appoint it unless they have at least 15 or 20% of the company. The reason being is if you end up with a board of 5 and you have to have a threshold of 20%, no one under 20% can get one of those seats. Now that's always up to negotiation, and depending on where you're at, people might push harder or less hard, but that's generally the rule of thumb. I'll hand over to Zoe so you don't have to listen to my answers at the moment, and she can have...
I'll have a crack at one of the questions, shall I? So we have a question here about whether you should wait to create a term sheet because the investor might want to set the terms or create one anyway. I think the answer to that question will depend on the types of investors that you're looking at bringing on board. As I think David mentioned earlier, institutional investors have somewhat set term sheets sometimes and like to start off with their term sheet and then negotiate from that position because that's the term sheet that they're familiar with. But if you are looking at a friends and family type round or a really early seed angel kind of round, then you can create a term sheet and that can kind of set the base level for the negotiations, and it can be beneficial for sure. Did you have anything else to say on that, David? Or?
No, I think that accurately sums it up.
Great. Can you see any others there that you'd answer, David?
Yes, I see one through. What are the legal terms of defining a bad leaver? So there's no hard and fast rule that a bad leaver has to be a certain category. Remembering that bad leaver provisions usually apply to founders, and sometimes they apply to all shareholders, but usually only ones that are providing services to the company. So when you're negotiating a bad leaver clause, you have the interests of the company, you have the interests of the founders, and you need to make sure that they're balanced. Founders shouldn't be able to do things that materially damage the company and then keep the benefits of the work of others after they leave. However, they shouldn't be so easy to be enforced that there's something that's potentially not that damaging, such as, any breach of an employment contract. It would be unusual for a simple breach of an employment contract, which might be you didn't give enough notice, or you had an obligation to provide a doctor's certificate or something like that. It's a simple breach of an employment contract would be covered there. So you want to make sure that they're for serious things. What we usually see is if the founder or the shareholder commits fraud against the company, that's a usually pretty high threshold. Then they've usually done something that's significantly impacted the value of the company, and they're considered a bad leaver. So the threshold for bad leaver should be high, but it is negotiable, and whatever you can get across the line with an investor will ultimately determine what situation is a bad leaver. Another question that came through, which not completely associated with term sheets, but another good point raised is, does anyone have does any suggested amendments to Airtree's open sourced advisor agreement, or is it fine to use? The first comment about Airtree's open source documents is the team over at Airtree are fantastic. They are doing startup community a wonder by releasing plenty of open source documents. I believe the advisor agreement is based on the Founder Institute FAST, which isn't unfortunately set up for the Australian market. But what I will say is, like all template documents, they are perfect for some situations, and in other situations they have limitations because they can't be customized. So there's nothing fundamentally wrong with using a template agreement. The problem is if you have a very unique situation with the services that an advisor is providing and there is some risk involved, a template document is very unlikely to take into account that unique search situation. If there is unique elements to the way you're offering the incentives under that agreement, then it's probably not going to take them into account either. So fundamentally nothing wrong with it, but it won't be customized to your needs. So to the extent that you're not 100% confident it is covering everything, then it's always good to have those documents reviewed.
On the subject of templates actually as well, just if you wanted to kind of go through what a term sheet looks like, there is what's called the Australian Investment Council has a template equity round term sheet that will include a lot of the things that we've discussed today, just so that you can get a sense of what that looks like. It could be a good document to refer to for sure.
Another question that's just popped through is, when investors want decision-making rights, is it a good idea to have a deadlock arrangement? So I think we sort of touched on this, but we didn't talk about what happens when there is a tied vote. So deadlock arrangements arise, for those of you that haven't heard of it, when there is usually a board decision, and if there's two directors, they have both voted in opposite ways on a resolution, so it can't pass. Now, if you can't pass the resolution, it fails and the decision just can't be made. There's ways to break that by doing a couple of things. Founders can sometimes give themselves more than one vote, or if they are the chair of the board, they can have the casting vote. So if there's a tied vote, whether it's 1-1 or 2-2, if you have a 4-person board, then the chair of the board, usually the founder appointed director, can break that deadlock. The other way to avoid a deadlock is to use an odd number of directors so that you just can't get a deadlock. The third option, which is sometimes used, and it really depends on who's sitting on your board, is if the board ends up in a deadlock, sometimes the decision can be reverted to shareholders so that they can break the deadlock based on their percentage ownership. Now, for founders, if you don't own enough of the company to make that decision yourself, it may not be a favourable way to break a deadlock, though if investors have enough power in the company and enough percentage, then they may not be willing to negotiate to give the founders too much control over breaking deadlocks. I think we've got time for a couple more questions. What else do we have here? Can you define ESOP? I missed that part of the presentation. So the ESOP that I referred to, and sorry for using acronyms, it's what's in Australia usually called as an employee share option plan. Sometimes another type of incentive arrangement you might have heard of is an employee share scheme, but essentially the employee share option plan is usually something that startups set aside quite early, around 10% of the company, sometimes 15 or 20 in certain circumstances, where you agree that over a period of time you can start issuing those options to employees as a way to incentivize their performance in the company, because you can't pay them at market or above market salaries in the early days. So it's important that you put that in the term sheet, because investors will want to know how much of the equity is going to be given to employees. And it's also important to know that investors actually look favorably on ESOPs. So don't be panicked by saying, oh, I want to do this, but I'm scared investors are going to be worried, because investors, usually the ones who are experienced in investing in startups, will actually have it as a requirement. And in some cases, investors may actually ask you to increase your ESOP.
All right, I think that's all the time we have for questions today. Thank you so much for submitting all your questions, and apologies if we didn't get to yours, but feel free to request a complimentary consultation and we might be able to answer them for you through that. The survey should appear at the end of this webinar. Thank you all so much for joining us. Hope you got a lot out of today's session. See ya.
Thank you.